story now. The Mpumalanga High Court has ruled a law graduate can practice without producing a copy of his degree. It found a rule forcing graduates to produce the copy before being admitted as attorneys or advocates is unconstitutional. The landmark ruling found in favour of Lindumu Samakamu. He graduated back in 2017 with a debt of 15,000 rand. To discuss this and what this ruling actually means, we're joined by legal expert Benedict Phiri. Mr. Phiri, good morning and thank you very much for your time. A very interesting judgment, and like many, will probably receive mixed reactions, and some court are seen as progressive. What's your take?
I think it's a very progressive judgment, and I think it really does give effect to the spirit of the legislation. The Legal Practice Act effectively says that if you want to be admitted as a legal practitioner, you have to prove that you've qualified for your legal degree. But what then needs to happen when you actually apply to court to be admitted, you then have to actually attach a copy of your degree certificate, which obviously goes further than just proving that you've actually qualified for your legal degree. And in this particular instance, this gentleman's degree certificate was being withheld because of the debt he had. But when you look at the actual rules, he should have been able to be admitted nonetheless, notwithstanding that he couldn't actually produce the actual degree certificate because he actually had completed his legal degree. So I think it's a good judgment because the courts shouldn't be sort of the gatekeepers between the relationship of debtor and creditor between a university and a student, especially in a situation where it speaks to him being able to practice his chosen trade and profession. So I think it's a good judgment and progressive and needed in the context of where we find ourselves.
Mm-hmm. The university, though, on their side is yet to announce if they'll perhaps challenge it. But what would be the prospects of success in as much as you're somebody that's already in support of the judgment?
Yeah, well, an application for admission is made ex parte in the sense that no other parties are invited to respond to that application. The Legal Practice Council is given an opportunity to comment on whether you'd be a fit and proper person to be admitted into the profession, or they're aware of other aspects that may not allow you to really be admitted into the profession. There was something that the judge said. The judge actually said in this matter that, well, we've got to consider whether this person with a debt outstanding would be a fit and proper person in the context to practice as a lawyer, because it's not desirable that as a legal practitioner, you haven't actually told the court what your plan is going to be with respect to settling this debt. So that aspect was traversed by the court, and the court noted that it might not actually be ideal to actually allow graduates to be admitted without actually an undertaking or an explanation as to, yes, even though you're admitting me, this is what I'm going to do to settle the debt, because it is important that as legal practitioners, we are seen to be people who actually give effect to the debts that we have. So that element was actually raised by the judge, in as much as in the same light, the judge said, the rule requiring the actual degree certificate is unconstitutional. But the judge did say, we might have to look at this in more detail to ensure that we don't have legal practitioners that have debts that are not settled, or at least do not give an undertaking around how they're going to settle this debt.
And I suppose particularly because with some they would be running trust accounts, so it would be important to get some sort of an undertaking. But insofar as the university is concerned, my question was more around the judgment itself, that do you foresee them perhaps challenging it? Because they would easily then say, going forward, universities would have no remedies. If somebody has failed to pay for the last part, that 15,000, then how do they recoup the funds with such a judgment? So I'm asking insofar as they're concerned, their remedies, because they wanted their 15,000. So now it has been stated that they actually can go on to be admitted, which served for them as some sort of a token or something they could withhold to ensure that people pay. So do you see them succeeding in court in that respect if they were to challenge this particular judgment?
The university does have a remedy. It hasn't lost a remedy in the sense that there is a debt owed to the university, and it's open to the university to bring proceedings to enforce that debt. I think what the court was saying here is that it doesn't need to be a gatekeeper in that relationship between a former student and the university. So, the university actually doesn't lose any rights by virtue of a judgment of this nature, because it can always approach the student through legal means and actually enforce that debt. So from my perspective, the university stays in the exact same position it was in. I think the university did have a little bit of an unfair advantage in the sense that now the court was basically giving effect to the debt arrangement in favor of the university without actually a court process which the university was involved in. So I think this does settle the scales, but the university still stays in the same position, and that right to enforce the debt against past students is not lost, and has the ability to do so at any given time should it wish to.
All right, Benedict, thank you very much for your insights. That was law expert Benedict Phiri.